Before we head back to court, let's bring in our guest. Joining us right now to discuss, criminal defense attorney, former head prosecutor Bob Bianchi. Bob, great to have you on with both of us. I want to talk about the demeanor of this defendant. For some reason, I felt like through this, she would be the kind of person that would want to tell her story. She started crying immediately, as we commented on, when she was asked about Joey. How do you think she's doing, just in terms of her attitude, demeanor, and the continuing tears?
I'm not impressed at all, but I have to ask myself, and I was really irritated listening to this questioning. First of all, the leading nature of the questions is not only legally impermissible, but here's the thing. When you lead, the story becomes about you, the questioner, and not the answers of the witness. So the witness is not being able to show a full spectrum of emotion because she can't get an answer out because of the leading nature of the question. Now, I know that if I were the adversary here, if I were the prosecutor, I could jump up a million times and say objection leading, and I'd be right. But I don't think I would tactically, because I know that this testimony is coming out stilted, unemotional, weird, and kooky. And I don't know if that's because of the witness or because of the lawyer.
Yeah, fair enough.
That's a fair point.
No doubt about it. The other thing is, it was obviously a calculated gamble by the defense. One of the things this jury is going to hear about, Bob, is her criminal background. So they're going to hear about 14 convictions, but they can't go any deeper. The state can't ask anything else about what they were about, et cetera, et cetera. And I think it was a good gamble because my argument is that part of her reason for not sticking around, for running, for engaging in the cover-up, is she didn't want to be connected to the police. She didn't want to deal with police. She was on probation. She's already dealt with police. And I don't necessarily think the information that she's got these convictions really hurts her.
I don't disagree with you, Michael. I mean, it really depends on the witness and it depends on the case. Of course, obviously, the evidence rule, maybe archaic, says that the four corners of the conviction are admissible because it could affect and impair the credibility of a witness. But I'm telling you, I have seen witnesses that have taken the stand that have had some really, really bad convictions. One of the funniest moments in a courtroom was a guy had like 30 convictions and he said, "Yeah, I'm a burglar, but I'm not a liar." And the jury died laughing, and they just liked him. They believed him. Of course, the lawyer on direct has to get that out because they know it's coming in cross-examination, so they're taking the sting out of it. How the jury will assess it, I don't know. I mean, I don't like the idea. 14 convictions, maybe what I'm seeing on the witness stand isn't really what I'm getting in reality. Who knows what the jury thinks?
Yeah, fair enough. And again, it all involved drugs.
And I can promise they're wondering what it involved. That's what the jury's thinking. What were those convictions for? They don't get to know.
All right, let's head back.